All rise. The Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Scott Makar, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good afternoon, everyone. Welcome to the 5th District's special sit-in in Palatka. And as I said this morning, we had two cases. We're very grateful to be here, thankful to everything that's been done to welcome us to the community. We have just one case on this afternoon's docket, and I appreciate the flexibility of the lawyers to come this afternoon versus in the morning due to various scheduling issues. So thank you, gentlemen, for being collegial and doing that. We had 20 minutes per side. The case is 23-125, Tyson versus State of Florida. We each have 20 minutes, and I know the appellant gets his reserved time. So, would you like to reserve time?
Yes, sir. 5 minutes, please.
5 minutes. Well, please approach and
Thank you, sir.
let's hear from you.
May it please the court, I'm Rick Sickton. I represent the appellant, Mr. David Tyson. And the issue presented today is whether the trial court is required to grant a new trial after the prosecutor violated his discovery obligations by not disclosing numerous documents used to impeach the defendant, Mr. Tyson, and then used those documents in closing argument to argue that Mr. Tyson and his entire defense got together and essentially conspired this story for trial. And so I think there are 4 main points that we all can agree upon, and I think it's important for context. The first is both the defense and the state had diametrically opposed testimonies. One was Mr. Tyson created this incident, he's the one that pushed the officer. The other testimony from 3 other witnesses was the officers created this incident and Mr. Tyson was defending himself. So those are the big 2 diametrically opposed stories in this case. And I think we all can also agree that there was multiple discovery violations. I did not see my colleague argue that there were not discovery violations. And the discovery violations in this case were a complaint, an internal complaint filed by the appellant's mother about this incident. And there were also 2 pages of emails that the state attorney used during the cross-examination of Mr. Tyson, appellant Tyson, to argue the point that the defense and his defense attorney got together and conspired. And so the third point that I think we can all agree upon is the judge, when the state attorney was trying to cross-examine the appellant on these emails that were not disclosed, the defense attorney objected and said, "You have to authenticate these emails." And the judge said, "I will give the state an opportunity to do so." That never happened. So we have a discovery violation, we have hearsay, and we have a defense attorney who is very upset that he moves for mistrial twice.
What about the waiver issue? Because that's a lot of what the state says. Waiver. Well, why was this not waived by virtue of a contemporary's objection, a Richardson objection, not part of the motion for new trial? Why is this issue preserved for our review?
He preserved it because when the state crossed Mr. Tyson as to the complaint during their initial cross-examination, when he did his direct, what the defense attorney tried to do is introduce that complaint. And the reason the defense attorney did so is he wanted to show the jury that this complaint was garbage, and that's not my words, he was essentially saying that. And when he was not allowed to do that, by the way, this is going to become important, over state objection, the state objected to the complaint as hearsay, even though they were using it to cross-examine the appellant. He then says, "I move to strike this testimony that was garnered from this complaint." And when the judge says no, he says, "I want a mistrial." This is all in the redirect. And the judge says, "Well, I'm not going to do that." And it kind of seems like you're moving for a discovery violation, some type of a Richardson violation. So the answer to your Honor's question is the judge acknowledged it was a Richardson violation.
What about the motion for a new trial. Why was it not part of it?
Don't know. I don't have a reason. It's not a part of the record. I think, I know it's not required to preserve the issue. I think what's required to preserve the issue is exactly what this attorney did, Mr. Baker did. And I think to this point on redirect, Your Honor, if you read the Marrero case, I think it's on all fours because that's exactly what the defense attorney did in Marrero. He tried to move the, Marrero, as my colleague points out, is trying to say that this issue wasn't preserved because what needed to happen was the defense attorney needed to object after the defense attorney realized that the state was not going to introduce this evidence. It's kind of a gotcha thing. And so what Marrero says is if you're going to insinuate that there's impeachment evidence out there, you got to prove it out. And the state had no intention of doing that. And so what my colleague argues is that because the defense attorney did not object at the end of the cross-examination, the issue is waived. But what my colleague misses is during this redirect, when the state objects to hearsay, the defense attorney knows right there isn't going to be any introduction of the complaint because the state itself is saying it's not admissible. So at that point, it comes all fours on Marrero. The waiver issues, which was omitted from the brief, is not relevant anymore. So the issue was preserved. And as you know, the case, you can tell through the record that the defense attorney is increasingly getting more frustrated. He then says it's D. Gaskins, and I had to look that up. I guess it was an infamous serial killer in Georgia. I don't understand the reference, but he also says, I can't believe we're just getting this stuff at the, surprising at trial. So he does it throughout the entire dialogue. And it was a really interesting dialogue. I haven't seen this in my 20 years of practice where the defense attorney's like, he's trying to say, this is not authenticated. The judge allows him to authenticate, but it doesn't happen. So
why did it matter? And I know the state brought it up during closing, which is fairly compelling.
Yes, sir.
If it wasn't germane or relevant, they wouldn't have brought it up.
Yes,
so obviously they thought it had some merit. But why did it make a difference here?
Because, as I mentioned at the beginning, where we all agree upon, these are two diametrically opposed theories, stories, and both of them, quite honestly, had their credibility issues. The officers had credibility issues too. They pulled up in the flanking position. They said that there were beach chairs there that were in the truck of Mr. Tyson, and they also said they removed the beach chairs and put them at the entry of the beach, but there's no pictures. The beach chairs just don't exist, and they were trying to say that Mr. Tyson was going to stay there. Instead of leaving, like Mr. Tyson's evidence said, that he was going to let his daughters use the bathroom and exit, and they couldn't exit immediately because there was a line of cars waiting for the beach. So there's two compelling different stories. And what the state did, and if you also read Marrero, it says that this is an ethical problem for the state because they're offering this insinuation that there is evidence that proves that Mr. David Tyson is a liar, but they don't offer the proof. And Marrero says you can't do that. You got.
So you're saying the necessity was your client had to testify to rebut the testimony of the officers, and credibility was everything, and this went directly to credibility.
Yes, and not only to the client, to the entire case and the defense attorney. The state argued, and that's a great point, Your Honor, the state argued in their closing, and the defense attorney also mentioned this, that the defense attorney thought that the state was trying to say that they all got together at his office and came up with a story. And if you read the end of the state's closing, this is why it's important. It's just not the statement that my colleague wants to point out, that whether he was kicked in the head or the face, like the state originally said for the reason to introduce this complaint in emails. And the state gives it away in their closing. They say he would not even agree with you that this is where the email came from. He wanted to deny it because the signature was not attached. So I submit to you, here's the most important part, that this was done in anticipation of trial. So they're trying to say that this was a conspiracy developed by the entire defense team. So it goes to all the witnesses. And my colleague says, well, it's not going to be procedurally prejudiced under Richardson because my client needed to testify. And we all know that that's not accurate. He doesn't have an obligation to testify. And
Are you saying he wasn't going to testify in this case?
I don't know, but what I am saying, Your Honor, is that the procedural prejudice here is that the defense attorney needed to get together and could have gotten together if this was properly disclosed and talked about these emails, because if you look at the record, my
Is that
client...
the only way your client is procedurally prejudiced here?
No.
So let me ask you about your initial brief. You said that the failure to conduct a Richardson hearing is per se reversible error.
I made a
That's
mistake.
incorrect.
I made a mistake.
Okay, so what is the standard?
The standard-
Shot.
Well, originally, it's an abuse of discretion if the judge conducts a proper Richardson hearing, and we know here it did
Okay,
not.
so he did not. So what's the standard?
I believe it goes to whether the defendant was procedurally prejudiced.
Or how the trial preparation would have been materially different,
Exactly.
correct? So how would it have been different?
It would have been different than he could have consulted with his client. He could have called his mother to introduce the complaint. He could have filed a motion to limine prior to trial to exclude this because it was clear the state had no authentication and they had.
Did you raise any of this in your initial brief? Or did you wait till your reply brief to discuss this?
I believe I raised it in both, but probably more specifically in the reply brief after the state made their arguments. I assume I made my counter arguments and brought this up. I don't know if I put in the motion in limine. I did think of that during oral argument, but the other ones, Your Honor, I believe I included them. And again, this is not my burden, right? Procedural prejudice is an extraordinary burden that's on the Attorney General's office. So it's not my burden to prove that. And so, Your Honors,
So what was the theory of the case? There's a number of cases out there that discuss a defendant having a theory of the case and then a discovery violation going into the heart of the theory of the case. So what was the theory of the case here for your client?
that he was on the beach, he wanted to let his daughters use the bathroom, that they traveled to 2 other beaches that day and were rejected or denied because it was a hot day. People were packed on the beach. And so we went to this beach that he's been to numerous times before. He pulled up to the guard shack. He wanted to have his daughters use the restroom in the ocean. And when he pulled up, our client said within 2 minutes these officers came. And the officer said, "You have to leave." He's like,
How did these discovery violations about this complaint hinder you from being able to present any of that?
didn't hinder presenting that. What hindered is it ruined the credibility because the state's saying that my client didn't even sign the emails that she was showing him. She was reading him.
So credibility is the theory that you're going after, saying that this hurt his credibility?
Not only him, but the defense attorney too, because the state said that the state suggested the defense attorney brought all the witnesses in, including my client's 11-year-old daughter, to come up with a story. And the defense attorney actually acknowledged that the state was doing that and argued that in his closing argument, that he believed that's what the state was doing. And the state used the word parroting in her closing argument to say that she believed that the 11-year-old daughter, who was, her testimony was directly the opposite of the officer. She said it was all the officers who instigated this issue. And so the state was arguing, well, they got together in anticipation of trial by filing this complaint. They brought everybody into the office, and she just parroted what everybody talked about would be their theory of the defense. So Judge Boatwright goes not only to the credibility, but it goes to the entire defense theory. It's a very damaging piece of evidence, and I think that's clear through the defense attorney's frustration through the motions that he...
So your point is having the information, if the state had not withheld it and violated the discovery obligations, that you would have been able to, you being your client and his trial attorney, been able to process that information in advance and come up with a way of undermining their attempt at his reducing his credibility. In other words, you could take sometimes the best defense is great offense. You could have been offensive on this issue, being taking it on, saying you bring in the mother and so forth. I don't know who would come in to testify about the emails.
Yeah.
It sounds like from the record, the other side can address it. We're not even sure they weren't under authenticated, right?
They were not.
So am I hearing correctly? That's at least one aspect of it.
That's one aspect, and the other aspect is I think these documents would have been excluded, and so the stigma would have been completely eliminated from the jury. This insinuation that there was this conspiracy between the defendants and their families and the attorney, because how can you? I mean, if you file a motion limiting, and like you said, Judge, I mean, these emails were never authenticated. The complaint actually had a typewritten, Xeroxed, cut and pasted statement that the state put on there and said, and so it's really kind of a hodgepodge kind of impeachment that these documents were not coming in. So
there was nothing in the opening statement that alluded to any of this.
It was a total surprise. And he mentioned that, the defense attorney mentioned that twice, and the judge acknowledged that it was a Richardson issue. But So with the prejudice, like I said, the state hasn't.
So just to follow up on Judge Maycar's point, nothing in voir dire, nothing in opening, nothing with any other witness, only with your client? It's
Yes.
the first time it came up?
Yes. Yes. And I think that's important because with the question she asked, then she was holding the state, that is, she was holding the emails and asking the appellant, Mr. Tyson, so you didn't sign this email saying, thanks, David? And if the jury's hearing, like paying attention at all, they're thinking like the client is lying. But the client has a legitimate defense. He could have brought in the mother, like Judge Boatwright was mentioning. There's a lot of things they could have done. They could have excluded it. They could have obviously talked to the client about this to prepare him for these types of questions, so he could have answered where these emails came from.
I guess my thought on this is there's a difference between trial strategy and trial tactics. And it's like, to me, strategy is more 30,000-foot strategy, and then various tactics that you might want to use. And the language seems to be from the cases that if there's it affects the change in trial tactics, that's what we're trying to look for. It doesn't have to be that your theory of the case overall changed, but how you would have addressed that theory and the tactics you would have used or not used is what's more to focus on.
I think so. Also, trial preparation, as Judge Boatwright mentioned. The trial prep, I think, is the most important part here because any decent defense attorney is going to prep their client for something that has their name on it, signed David Tyson.
Part of the mystery to me is what's the big deal about his officer kicked him repeatedly, correct?
He admitted to at least once. The daughter said 3, and he said repeatedly.
I mean, after he was on the ground and so forth, he was kicked.
Yes.
And I'm struggling. There seems to be this idea that we're going to make your client look bad because he said he got kicked in the face versus kicked in the head or something back of the head. I'm still struggling. Why was that introduced only through these discovery violation documents? That idea, or was it elsewhere in the trial?
It was an interesting idea. So in the cross-examination originally, Mr. Tyson said he interchanged head and face. He said it, and so when I read that, I didn't even realize or think how this was relevant because he's admitted both that the state was trying to impeach him on. He said it in his cross-examination. It's clear. So reading from the record did not seem to me that was the overall reason why these documents were coming in. The overall reason for these documents coming in is because the defense could not do anything about it. And then they could argue what they were trying to formulate earlier. Their theme is conspiracy with everybody.
But didn't they say in closing something about, he said head, he said face, whatever,
He did.
to make him look not credible?
Yeah, along with the other things I mentioned, they definitely did that. And what else did I want to mention?
And you're in your rebuttal time. I'm not sure.
Yeah, I will stop and reserve the rest.
328.
Unless your honors have any more questions for me right now. Thank you.
All right, let's hear from the state. Is this Mr. Wilson?
Yeah.
May it please the court, my name is Adam Wilson. I'm here on behalf of the state. We're asking you to affirm the judgment and sentence in this case. Going to the Richardson violation, I think the first important thing to consider is...
You concede there was a Richardson violation.
I concede that if this issue had been properly preserved, the trial court should have held a hearing. I don't think the record allows me to take a position on whether this was actually a discovery violation.
Well, you wouldn't commend this practice,
No.
would you?
Absolutely, no. This is not how I...
Concessions are okay.
Yeah, so...
They bring about credibility.
Yeah, so, the record doesn't allow me to, but this is not the way I would have conducted the trial. But going to preservation, I think it's important
Or
to...
conducted the prosecution.
Sorry, what was that?
You said conducted the trial. It's not the trial judge's conduct. It's that brought about the discovery.
Yeah, so the failure to turn over the documents is the conduct of the prosecution, but the failure to hold the hearing, if it had been properly preserved, would be the trial judge's decision. But the preservation issue in this case, I think it's important to explain. So basically, the defense is cross-examining Mr. Tyson. They asked him about this complaint, essentially to get him to admit to the statement that you guys were talking about, where he says, I was kicked in the face instead of the head. They ask him about the complaint. They ask him several questions about the complaint. They refresh his recollection with the complaint. Silence from the defense. Then the defense does a redirect, asks him about the complaint. Still nothing. Then the defense tries to introduce the complaint into evidence, which is obviously not allowed because it's self-serving hearsay. At that point, while making his argument, the defense notes that I didn't get this, it wasn't turned over on time. And that, I don't think that's preserved because the preservation has to be contemporaneous.
And I hear you. Trying cases is not easy.
Yeah.
And so in real time, Mr. Baker is dealing with something he didn't anticipate. What I hear the state saying is he should have been prescient enough to appreciate something he didn't anticipate was going to happen and object and cite to Richardson in real time. Isn't that what you're saying?
No, I don't think he has to be prescient. I just think you have to make a timely objection. We impose this restriction on all sorts of objections. It's not that, I don't think the case law is such that you have to guess that they're going to bring in this evidence, but you have to object when they do, or at least at some point close to when they do. You don't go through the entire cross-examination.
Now, he did it, you would concede this, he did object during the testimony of the defendant, correct?
He did not object until the recross. Oh, sorry.
But it was still, I mean, the defendant was still on the stand.
Yes, absolutely.
And
But
he asked for a mistrial. He asked for a mistrial, correct?
that was in between that was during his redirect.
Both for the complaint and the email, correct?
Yeah, well, I don't exact, his mistrial motion was more so, I think, garnered toward the kind of Marrero authentication issue. He never asked for a mistrial because I didn't get this. It's contained within it. That's, I think, a completely separate argument that he's making. And so it's the fact that he allowed this to go on for so long is why it isn't preserved.
Should we agree with the appellate that this case is about credibility?
I believe credibility was an important factor in this case, yes.
These two documents went directly to the defendant's credibility, didn't they?
I think, yes. I think Judge Maker's point about the difference between kick in the face and a kick in the head is well taken. I think that statement is extremely minor, and that in fact goes to why he wasn't procedurally prejudiced.
Well, and I hear you on that, but I thought a fairly compelling moment was on the fact that he said he didn't send these emails that had his name on them. I mean, that sort of hurts your credibility. I mean, you've got emails that the jury never sees, but the prosecutor is asking him, did these emails with your name on them, were they sent by you? And he says they were not. Don't you think that went directly to his credibility?
I think the exchange with the emails did affect his credibility in a negative manner, but the objection to the emails, the objection specifically to the emails was even weaker than the objection to the complaint, because if you look at the record, it's in the middle of his authentication argument that he makes, I think the statement was, I love that we're getting this now, getting this stuff at trial. It's not even clear that he's referring to the emails, and it sounds more like a crack at opposing counsel, this is an extremely contentious trial. Starting from the beginning, they're taking shots at each other whenever they can. And so that's not a specific enough objection for the trial court to know that he wants a Richardson hearing or any relief for this discovery.
Well, out of Judge Daniel's mouth, he says Richardson, correct?
That's before the emails. So to be clear, he goes...
Related to the internal affairs
complaint, exactly, Your Honor. He brings up the Richardson, I think he says, you're talking about some sort of Richardson violation. That's in response to the discussion of the actual complaint. But then later on, the emails come in. So after the defendant is done, the defense attorney is done on redirect, then the state asks for recross to bring in the emails. And that's when the statement, I love that we're getting these now, comes
So if
in.
there's a Richardson violation, what is your burden in your shot?
To show beyond a reasonable doubt that the error was harmless.
Okay, you think the state did that here? Is it that the error is harmless, or that it did not materially affect trial preparation?
So the error is harmless because it did not materially affect his trial preparation.
Okay, what is your argument as to that?
As to the complaint, I think 3 specific circumstances in this case demonstrate that. Most importantly is the fact that this is very weak impeachment. I don't even know how much of an effect it had on his credibility. The difference between being kicked in the face versus kicked in the head is not, I wouldn't have even bothered trying to make this distinction. I don't think that affected his credibility very much.
Didn't it get brought up in closing, though, that he's saying he never made this complaint, and so the state kind of attacks his credibility there?
I believe that was in the rebuttal closing. It was actually brought up by the defense attorney, I believe, first in his closing argument. And in the defense's closing argument, he brings this stuff up to show, he argues that the state is so desperate here that they're resorting to this. So I think even he is acknowledging that this is not very impressive impeachment.
But that would never have been said had this document not been utilized, correct?
She asked him before she brings the document in if he previously said that, and he admits to previously saying that. So I'm not sure it wouldn't have ever been said.
But not in this complaint, though, correct? I mean, he denied making the complaint the way it was read to him.
Yes, he denies making this specific complaint, but what she asked him originally is, didn't you in your excessive force complaint, I'm paraphrasing a little bit, didn't you in your excessive force complaint say that you've been kicked in the head 5 times? And he admits to saying that. Then later she tries to refresh his recollection with whatever specific
I guess
version.
My point's a little bit more basic. That question never happens without the complaint being a feature of this trial. She never asked that question because she would never ask about the complaint that she never provided to the defense.
If the complaint didn't exist, he would never would have had this prior inconsistent statement, to the degree that it is actually inconsistent, which I think is really not that, it's really not that inconsistent, because like, what is the side of your eye? Is that the side of your head or your face? So I don't think that was very damaging. It did, and I mean, this is also illustrated by the fact that the defense attorney tries to introduce the complaint into evidence. Like, he doesn't. It actually supports his theory of the case. I think the theory of the defense's case here is that the officers used excessive force, and then they're lying to cover up the fact that they overreacted and assaulted the defendant before it was warranted, and then they are framing him for having the gun on the beach. And so the complaint tends to suggest that they're actually undergoing an investigation for this conduct, and it also kind of bolsters the defendant's testimony because it shows that prior to trial he was willing to file a complaint about this and make this statement, and the fact that I guess his mother initially filed the complaint tends to bolster his testimony as well. And additionally, I think the fact that he gave this complaint to law enforcement suggests that he wasn't really surprised by the state showing up with this complaint. He gave it to law enforcement 2 months before trial. And so it's not quite the same as certain other discovery violation cases where the discovery is something you wouldn't expect the state to have, perhaps. Here, he gave it to law enforcement, and then they show up with it at trial. He gave it to law enforcement 2 months before trial, and then they show up at trial with it.
What's the factual basis for that? He gave it to law enforcement?
That he said he filed a complaint with the.
This is when he's been examined.
Yes, he admits to filing.
The surprise.
Yeah, I believe his testimony is that he didn't file. He admits to filing a complaint. I think at one point he suggests that he maybe told law enforcement over the phone and they typed it up, but he starts to kind of waver on whether he wrote the specific version the state has, and I think it comes out that he didn't write that because of, I don't know what the state
Well, it seems to me it makes a stronger case for appellant that we're not really quite sure about this report. Meaning, okay, did the mother file it? Did he supplement it? I don't know. It just, all we know sitting here is that he was surprised. So here's this document, and asked on the fly for the first time in his criminal proceedings and answer questions about it.
They're asking him whether he made that statement. He admits to making the statement. I don't think it's really relevant whether he actually wrote this specific complaint. He also admits to taking over his mother's complaint, so I think that would be an adopted admission anyways. But I think the important fact is that he admits to making the allegedly impeaching statement. He admits to making the statement that I was kicked in the face 5 times beforehand. And that's they're not impeaching him with the complaint, they're impeaching him with that statement.
It just seems to me if the state had done what it was legally required to do, to turn over these documents and they plan to use them, they could have been on the offensive in presenting their case and saying, you know what, here's our narrative about what happened. We were the ones that were, I was the one who was abused by the police, and I was knocked and tased in front of my daughters and knocked to the ground and kicked in the head or the face, wherever.
I think that is their defense. I think they bring that up. They have both the daughter and the friend both testify to, I think the daughter testifies pretty much similarly to the defendant, that the officers just basically attacked him before they had any belief or reason to do so. The friend testifies about several kicks to the head after he's clearly on the ground and stuff. So I think they did actually use the allegations of misconduct in an offensive way. And there's also the fact that the defense attorney, starting from his opening statement, repeatedly refers to an internal investigation of these 2 officers. He brings it up in his opening statement. He brings it up in the cross-examination of each officer. And that suggests that he does actually know about this complaint. And that that's an additional reason why.
An internal investigation going on in the sheriff's office without having the defendant make the complaint, correct? Doesn't the sheriff's office do that on their own sometimes in cases like this?
Yeah, but he knows that he advises the defendant not to make a complaint. I mean, yes, it's possible that he didn't know, but I think the fact that he is asking about this the fact that he knows about this internal investigation that was started by this complaint strongly suggests that he also knows about this complaint that his defendant filed.
So any documents that he may know about, you can just hold back.
I would not advise that. No, that would be unethical. But I think if the defense knows about it, it's a factor to be considered in determining whether the defendant was procedurally prejudiced. Turning to that, the Marrero error, or that isn't preserved either, because to properly preserve this type of error, you have to wait until the state has had an opportunity to introduce evidence and fails to do so. So the motions for mistrial were premature, and that's straight out of Marrero. That's what the court said in Marrero, is that you have to wait until the state because the error doesn't actually occur until the state insinuates the existence of impeachment evidence, the defendant denies it, and the state fails to prove the existence of the impeachment evidence. And so by objecting too early, he did not properly preserve this. Even if he had properly preserved it, I don't believe there's any error here, because the defendant admits to making this statement, and so that's completely different than Marrero or Evans or Brady.
I hear what you're saying, counsel, but again, it's just one more inconsistency, because the prosecutor makes much of the fact that he won't admit that he wrote what she's reading to him. And it's just one more credibility hit on this defendant. You would agree with that, would you not?
I would agree that his failure to admit did hurt him and stuff. But I think the Marrero error is the fact that he failed to strictly referring to the statement that he made, and he admits to making it, so there is no Marrero error, because he admits to making the statement. The jury isn't going to be confused, and the problem isn't going to think that there's some kind of impeachment evidence out there floating around that couldn't come into the trial. They're going to think that this impeachment evidence exists because the defendant admitted it exists by admitting to making that prior statement. So for that reason, I don't think there was actually a Marrero error here. And if there are no further questions, I'd ask that you affirm. Thank you.
Yeah, thank you, counsel.
Briefly addressing my colleague's points. In Copeland, which is the first DCA case, 1990, issued by Judge Wolf, he explains that this issue, a Richardson issue, the timing is not critical on a Richardson objection. What's critical is that the judge conduct a necessary requirement, because discovery violations are bad things. They ruin trials. So in Copeland's directly addresses this issue that, like Judge Jay, you said, it was objected during the defendant's testimony. Absolutely. And Copeland says that the timing is not critical. He did it before the defendant was done with his testimony. Copeland says that erases any question of procedural bar. The second issue, I brought it up during my initial statement, but the state wants to distinguish itself from Marrero. But as I pointed out, when the state objected to the complaint as being hearsay, Mr. Baker knew right then and there that they weren't going to prove the complaint through evidence. And so Marrero is on all fours. Actually, if you look at pin site 1158, Mr. Baker did the exact same thing that the defense attorney Marrero did, that Marrero wanted, and he objected. He moved to strike that testimony. When that testimony was not struck, he moved for a mistrial. And so, and Judge Day, you brought this up, the credibility is a big issue, and I'd like to end my discussion with the Florida Supreme Court under Shop recognizes that the vast majority of cases, the record is going to be insufficient to determine whether there is a finding of harmless error. So in this case, we're going back and forth as to what this complaint was, what these emails were. So Shop is another persuasive case that says we're confused here. All of us are confused what happened with these complaints and emails, and because it's not readily apparent in the record that there's harmless error, reversal is required under Shop. And finally, with credibility, the state in the rebuttal spent a significant portion of time. I don't want to use the word bolster because that kind of insinuates improper argument. But what they did is that they pumped up the officers. They said they have no reason to lie. They're credible. They were very credible, and that's on purpose because the state knows that when it's a credibility determination, she's got to pump up her case and at the same time use this complaint and email to allege that the defense's case is completely unbelievable because they got together in the office and they created it. And the daughter got up there and just parroted everything. So there is a Richardson violation. The judge acknowledged it, as Judge Jay indicated. The prejudice is clear because the procedural prejudice could have erased this entire specter of filing a pretrial motion in limine or preparing the client to deal with these matters and calling additional witnesses to smooth out what this was. And finally, I got 33 seconds left. The state says, well, Mr. Baker might have known about this. I think Mr. Baker's language during this discussion, this cross-examination, is pretty clear that he was surprised. I mean, he's upset to the point where the judge is telling him to essentially sit down and be quiet because he's heard enough. So
he's an excitable client.
Right? Yes. That's fair. So I would ask this court to follow Marrero for the hearsay emails, and Goldsmith, which my colleague left out of the brief, which deals with a Facebook message similar, where they introduced it at the trial and said, "Is this your nickname, Biggie?" And he said no, and that was a discovery violation, and the court said because the client did not have an opportunity to talk with his attorney about this before, they could not prove that it was harmless. And I ask this court to reverse.
Thank you. Well, this brings to a conclusion our wonderful trip here to Putnam County, and I guess the first ever sitting of our court here in Palatka. And I want to again extend the thanks to the graciousness of our hosts, of our association, the court itself, the advocates who willing to change their schedules to come down and be with us. I can probably say on behalf of my colleagues that we've enjoyed our time here immensely, and we'll look forward to coming back in the future. And with that, we will be in recess.
All rise.